does not deserve armed royal protection. The principle of it's horrible because he's left the United Kingdom, he's relinquished his royal duties, and he's spent the last few years attacking the monarchy and the United Kingdom and the royal family.
More than £100,000. That is the figure that emerged from High Court testimony this week, and it landed like a grenade in the middle of Prince Harry's lawsuit against the Daily Mail publisher. Researcher Graeme Johnson confirmed under oath that he paid that sum to 6 individuals whose claims are central to the Duke of Sussex's legal case against Associated Newspapers Limited. 6 people. All of them, as the court heard, serendipitously feature in the very accusations Harry is making against the tabloid giant. Serendipitously. That word hung in the courtroom air with all the subtlety of a fire alarm. Having followed this story for years, I have watched Harry wage war against the British press with the fervor of a man convinced he is fighting for justice. He frames himself as David against the Goliath of Fleet Street, a crusader exposing the dark underbelly of tabloid journalism.
The king does not want to be involved in this. It's legal jeopardy. And also, of course, the king simply doesn't. He's simply too exhausted to have time or energy to deal with the ongoing sagas surrounding Prince Harry.
But this week, the courtroom revelations painted a very different picture. When your key witnesses have been paid large sums by a researcher working in your corner, the question stops being about what the newspapers did. The question becomes whether the evidence against them has been purchased rather than discovered. The stakes here are enormous, and they extend far beyond Harry's personal grievances. This is a man who walked away from his family, his country, and his duty to pursue what he calls accountability. He has staked his entire post-royal identity on being the truth teller, the one who will drag media corruption into the light. If the foundation of his legal case crumbles under the weight of paid testimony, everything he has sacrificed looks not like principle but like petulance. The High Court proceedings are ongoing, and what emerges next could determine whether Harry's crusade has any legitimacy left at all. Let me walk you through exactly who received money and why it matters so much to the integrity of this case. The largest payment went to Gavin Burrows, a private detective who pocketed £75,000. Burrows is not some peripheral figure in this legal drama. He is the man who made the most explosive claims about phone hacking, landline tapping, and bugging. His allegations form the backbone of some of the most serious accusations Harry has leveled against the Daily Mail's publisher. Without Burrows, the case loses major firepower. Here is where the situation goes from concerning to potentially catastrophic for the Duke. Burrows has now turned around and declared that his witness statement is completely false, not partially inaccurate, not taken out of context, completely false. He claims his signature on that statement was forged. The man who was supposed to be a star witness has basically set fire to his own testimony and walked away from the wreckage. The court also heard about payments to Glenn Mulcair and Greg Miskiw, both convicted phone hackers. Mulcair received £22,000 while Miskiw was paid £12,000. With these transactions occurring between 2015, these are not innocent bystanders who happen to have useful information. These are men who went to prison for illegal phone hacking. Their involvement cuts both ways. Yes, they have insider knowledge of tabloid wrongdoing, but they also have every reason to tell a paying customer exactly what that customer wants to hear.
This is about his safety. I don't think that is what this battle with the UK government and the Home Office, I think it's about his ego.
Steve Whittemore rounds out the rogues gallery of paid sources. He was convicted of breaching information laws back in 2005, yet Harry's side apparently thought it wise to pay him £5,000 in 2021. Daniel Portley, a US-based private investigator, received £6,000 for work on a book plus additional funds for his archive. Christine Hart, another private investigator, also collected £5,000 from Johnson. The pattern is unmistakable. Person after person with questionable backgrounds received large payments, and person after person now features prominently in the legal case against Associated Newspapers Limited. From what I have seen, this is not what building a legitimate legal case looks like. This looks like assembling a team of paid consultants whose job is to deliver damaging claims on demand. The question every observer must now ask is straightforward. When you pay someone £75,000 and then their testimony appears in your lawsuit, are you getting the truth or are you getting what you paid for? The answer to that question lies in following the money, and the trail leads to some unexpected places. Most of the funding for these payments came from Max Mosley, the deceased multi-millionaire privacy campaigner who spent his final years crusading against tabloid intrusion. Mosley had his own reasons to despise the British press after they exposed aspects of his personal life he would have preferred to keep hidden. His fortune continued supporting anti-tabloid efforts even after his death, with payments flowing through a company linked to his estate. The man may be gone, but his money kept working against newspapers he loathed.
And I think that's actually what the armed cops is about. I think it's his ego. It's humiliating for him to come to the UK and not have those cops.
Additional funding came from what was described as a loan from Evan Harris, the former Liberal Democrat member of Parliament and a prominent member of Hacked Off, the campaign group that has made media reform its central mission. Harris is not some neutral party who happened to have spare cash. He is an activist with a stated agenda against the tabloid press. When loan money from an anti-media campaigner funds payments to people who then provide anti-media testimony, the appearance of coordination becomes difficult to ignore. The specific payment structure to Burrows deserves particular scrutiny. Johnson paid him £25,000 for what were described as extensive notes and commentary. On top of that, Burrows received £5,000 monthly for 10 months as part of a deal to work on a memoir. That totals £75,000 flowing to a single individual, dressed up as research fees, book contributions, and consulting work. The creative accounting here would make a forensic accountant reach for a stronger cup of coffee. What emerges from the court testimony is a picture of systematic financial relationships between an anti-tabloid researcher and the very people whose claims would later form the basis of legal action. The payments were not one-time transactions. They were ongoing relationships that created financial dependency. When your income depends on someone who needs damaging information about newspapers, your incentive to provide that information becomes considerable regardless of whether it reflects reality. Associated Newspapers Limited has maintained its innocence throughout these proceedings, describing the accusations against them as preposterous and insisting all articles were sourced through entirely legitimate reporting. Whether that defense holds up remains to be seen, but the revelation of these payments gives the Daily Mail's lawyers ammunition they never could have purchased themselves. The integrity of the testimony against their client is now fundamentally in question. Anthony White, the barrister representing Associated Newspapers Limited, went straight for the jugular during the High Court proceedings. White put it to Johnson that there existed a pattern of payments or promises of payments to people to provide evidence that can be used against Associated on newspapers more generally. This was not a casual observation, it was an accusation of systematic corruption of the evidence-gathering process. White suggested it was part of Johnson's modus operandi to investigate unlawful information gathering by making payments to people who could provide potentially helpful evidence. The core problem White identified strikes at the heart of how legitimate investigations work. When you pay sources, you introduce bias into the information you receive. Someone receiving regular checks has every incentive to keep those checks coming. The way to keep the money flowing is to keep providing useful information. Whether that information is accurate becomes almost secondary to whether it is valuable to the person writing the checks. Johnson was confronted with his own email showing he tried to persuade Mulcair to raise his game. Think about what that phrase reveals. Raise his game. This is not the language of someone passively receiving whatever information a source provides. This is the language of someone pushing for more, encouraging a source to deliver bigger and better material. It suggests active manipulation of the evidence-gathering process rather than neutral documentation of facts. The testimony purchased under various pretexts now forms the backbone of Harry's legal argument against the Daily Mail publisher. That connection is what makes these revelations so devastating. It is one thing for a researcher to pay sources for background information that shapes journalistic investigation. It is quite another for paid-for material to end up as evidence in active litigation. The line between research and witness tampering starts to blur in uncomfortable ways. Having watched this unfold, I find myself asking whether Harry's legal team did adequate due diligence on where their supporting evidence originated. Did they know about these payments? Did they ask? The answers to those questions matter enormously for how we understand the Duke's role in this situation. Is he a victim of overzealous allies who cut corners, or was he aware that the case being built on his behalf rested on purchased testimony? Neither answer reflects well on a man positioning himself as a champion of truth. Graeme Johnson mounted his defense in the courtroom, but the explanations offered raised more questions than they answered. Johnson claimed the payments were made for journalistic reasons, not to secure witness evidence. He stated directly that he never paid for witness evidence which was used in legal proceedings. He insisted he had taken legal advice multiple times, including written advice, and that he stuck with and complied with that guidance. On its face, this is the defense of a man who believed he was operating within proper boundaries. The problem is that the court can draw direct lines between the information Johnson paid for and the evidence now being presented against Associated Newspapers Limited. The material did not stay in journalism. It migrated into legal proceedings. Whether Johnson intended that outcome or not, the result is the same. Paid sources became witnesses. Research became evidence. The wall between journalism and litigation collapsed. Johnson defended himself by noting that he had written many articles about the group and placed interviews with some paid sources on the BBC's Panorama and other outlets. He argued that he took this story, a dead story, and got it part of popular culture again. This framing presents him as a crusading journalist who revived an important issue. What it does not address is whether paying sources corrupts the information they provide regardless of what noble purposes that information might later serve. The distinction Johnson tried to draw between paying for research and paying for testimony may not survive contact with legal reality. Associated Newspapers Limited's lawyers appear ready to demonstrate that the paid information flowed directly into the current court case. If they succeed in making that connection explicitly, Johnson's protestations about journalistic purposes will look like semantic games designed to obscure a fundamental breach of evidentiary integrity. What strikes me about Johnson's position is the confidence with which he describes his own conduct. He does not appear to see anything problematic about the payment structure he established. That confidence may stem from genuine belief in his own righteousness, or it may reflect years of operating in an environment where the ends justified the means. Bringing down tabloid newspapers he viewed as corrupt may have seemed important enough to overlook how the evidence against them was being assembled. This is not the first time Harry has faced embarrassing revelations about the strength of his claims against British newspapers, and the pattern should concern anyone taking his side. The Mirror Group newspapers case from a couple of years ago provides a troubling precedent. Harry accused MGN of phone hacking and took the witness stand himself to make his case. What followed was, by most accounts, a bloodbath. The MGN barrister systematically dismantled Harry's claims by showing that information he insisted could only have come from phone hacking was actually reported by other newspapers days earlier. In some instances, the information traced back to Harry's own statements to the Associated Press. Time after time, the Duke would insist that a particular piece of information in a tabloid story could only have been obtained through illegal means. Time after time, the defense produced evidence showing legitimate sources for that same information. Harry's certainty crumbled under cross-examination. His conviction that he had been uniquely victimized met the cold reality of documented public records proving otherwise. The pattern that emerged from the MGN case is one of assumption dressed up as knowledge. Harry believed he was hacked. He felt violated by tabloid coverage. But believing something and proving something are different exercises entirely. His emotional certainty about wrongdoing did not translate into evidentiary certainty about specific illegal acts against him specifically. Now we see a similar active potentially unfolding in the Daily Mail case. Harry has absolute conviction that he was wronged. His legal team assembled what they believed was damaging evidence, but the foundation of that evidence is cracking. Burroughs claims his statement was forged and false. Johnson admits to paying sources large sums. The case that seemed solid on the surface reveals termite damage underneath. From what I have observed across both legal battles, Harry displays a consistent tendency to conflate his general grievance against tabloid journalism with specific provable claims against particular publications. He knows the tabloids treated him badly, of that there can be no doubt. But knowing the press was cruel does not automatically mean every specific accusation he makes is supported by evidence. The MGN case showed his claims could not always withstand scrutiny. The Daily Mail case may be demonstrating the same vulnerability from a different angle. The consequences of these legal adventures extend beyond courtrooms and into family relationships that may never recover. King Charles is reportedly furious about Harry's ongoing press lawsuits, according to multiple royal commentators. The monarch wants complete distance from any litigation, which places him in an impossible position when his own son insists on remaining perpetually entangled with British courts. Every time Harry appears in London for another hearing, the palace must calculate how to avoid association with proceedings that could reflect badly on the institution. The awkwardness compounds when you consider that a former Daily Mail journalist now serves as Charles's press secretary. The King's communications operation is run by someone who worked for the very publication his son is suing. Navigating that conflict requires diplomatic skills that would test the most experienced courtiers. How do you serve a king while your former employer is accused by the king's son of systematic illegality? Royal commentators have noted that Charles simply cannot afford to be associated with active litigation. It violates long-established principle that senior members of the royal family, particularly the sovereign, must not be connected to ongoing legal proceedings. Harry's insistence on pursuing these cases forces his father into a position where supporting his son would compromise the monarchy's neutrality. The institution must come first. The son has made himself incompatible with that priority. Reports suggest Charles is simply too exhausted to deal with the ongoing sagas surrounding Prince Harry. The king is battling cancer while managing the demands of the throne. He does not have spare emotional bandwidth for a son who seems determined to drag the family name through courtrooms in pursuit of grievances that grow more questionable with each revelation. Exhaustion is not estrangement, but the practical effect is similar. Harry has made himself too much trouble to engage with meaningfully. What makes this particularly tragic is that Harry once had a purpose. He had a role that suited him. He had people who looked up to him. He had a grandmother who needed him, and he walked out on all of it. The proceedings continue in the High Court, and what happens next could determine the trajectory of Harry's remaining credibility. Associated Newspapers Limited maintains its strong denial, continuing to characterize the accusations as preposterous and insisting on the legitimacy of its reporting. The publisher has not wavered from this position despite years of litigation. If anything, the revelations about paid sources have strengthened their hand. They can now argue that the case against them was constructed rather than discovered, assembled by people with financial incentives rather than uncovered by disinterested investigation. The forged signature claim from Burroughs could prove nuclear if substantiated. A key witness saying his statement is completely false and his signature was forged does not leave much room for interpretation. Either Burroughs is lying now to escape consequences, or someone involved in building this case committed fraud. Neither option reflects well on the legal effort Harry has championed. The trial continues with Associated Newspapers lawyers expected to directly connect paid research to evidence currently before the court. If they succeed in drawing those lines explicitly, the implications extend beyond this particular case. It would suggest that an entire apparatus of anti-tabloid investigation has been operating on corrupted foundations for years. Stories placed with major outlets like the BBC's Panorama might need re-examination. The broader credibility of claims against tabloid newspapers could suffer. Harry faces a stark reality depending on how these proceedings conclude. If he loses, his crusade against British media collapses in the most public way imaginable. Years of positioning himself as the man brave enough to take on Fleet Street would end in defeat and humiliation. The narrative of Harry the truth-teller would give way to Harry the man who could not prove his claims despite dedicating years and millions to the effort. But the stakes transcend winning or losing in the conventional legal sense. If the court determines that evidence was tainted by financial arrangements, Harry becomes associated with a corrupted process regardless of the technical verdict. Even victories achieved through questionable means carry asterisks. The Duke might win a judgment while losing the moral authority he claims motivates his entire campaign. Having followed this saga from the beginning, I cannot escape the conclusion that Harry fundamentally misunderstands what he threw away and what he pursued instead. He was a prince with a purpose. The military work mattered to him and to the veterans who saw one of their own serving in Afghanistan rather than hiding behind palace walls. The charity patronages connected him to causes larger than himself. The Commonwealth duties gave him a global stage to do genuine good, and he just left it behind. He walked away from a role that millions of people valued, that his grandmother needed filled, that his country expected him to honor. The argument that this was necessary for his mental health might hold water if his post-royal life radiated well-being. Instead, he appears more aggrieved than ever. He has traded structured purpose for endless litigation. He has exchanged a defined role for an amorphous quest that produces embarrassing headlines rather than meaningful achievements. The man who wanted freedom now seems trapped in a cycle of grievance that he cannot escape and cannot win. What Harry called standing up for himself looks more like abandoning his post with each passing month. Standing up for yourself does not typically mean suing newspapers for years while your evidence base crumbles. It does not mean alienating your entire family over grievances that legal proceedings cannot satisfactorily resolve. It does not mean leaving your aging, ailing father to manage institutional crises while you chase vindication in courtrooms. The military work is gone. The charity patronages belong to others now. The Commonwealth duties carry on without him. His grandmother died without the relationship she deserved with her grandson in her final years. Everything meaningful about his previous existence has evaporated, and what replaced it appears to be litigation built on questionable foundations, and a marriage to celebrity culture that produces jam brands and Netflix specials rather than lasting impact. I want to hear your take on where this goes from here. Comment below and hit subscribe if you have not already. This story is still unfolding in real time, and the next courtroom revelation could be the one that finally settles whether Harry's crusade was ever justified, or whether it was always destined to collapse under the weight of its own contradictions. The High Court proceedings continue. The evidence keeps getting examined, and Prince Harry keeps betting everything he has left on the hope that this time, his claims will hold up under scrutiny.